Okay, good evening, everybody. Welcome to Gamma's webinar on estate planning. So we have Mahesh on this call with us. Most of you know Gamma is also a 501c charity organization, and we organize different types of charity events throughout the year. And this year we had a walkathon, a charity fundraising event, and every year we give scholarship to our kids in the community, and we are going to do this year also. This webinar is part of this charity effort by Gamma, and um, thank you, Mahesh, for joining the call, for attending, for accepting our request and joining the call. Mahesh has more than 30 years of experience in real estate, estate planning, and franchisee law. He's an expert in this area. Yeah, with that, I'm passing to Mahesh. And about the questions, if you have any questions during the session, please ask the questions, or we have a Q&A segment by the end, so you can raise it over there also, or you can put on the chat so that one of us can organize and raise it. Okay, back to you, Mahesh.
Great. Thank you, Sisimon, and the Gamma Board of Directors. Appreciate your giving me an invitation to speak to the community at large about one of my favorite topics. I've been doing this for a better part of 30 years of my life. And I equate estate planning work to be in the field of medicine, to be preventative medicine, because if you have what we're going to discuss today in your portfolio of documents, you would have prevented a lot of headaches for your family members, including your husband, wife, your children, and the so with that, somebody put that one on mute. There you go. Thank you. Thank you. So by way of introduction, I practiced law in the Dallas-Fort Worth area for well over 30 years. One of my passions is estate planning. I went to the University of Miami back in 1994 to get my master's in estate planning, NYU Law School to get my master's in taxation. So this is a near and dear to my heart. Like I said, I can do this in my sleep, and I take a lot of passion in my work, especially educating people. And that's the focus of today, is to educate people, not to sell you on any certain item, but to answer your questions, take away a lot of the mythology that goes around the estate planning process. And one of the key factors is that people say that if you don't have a will, that the state will take everything, which is absolutely not the case. The state of Texas, nor any other state in America wants your assets. Matter of fact, 80% of Americans have no wills or powers of attorney, any of those documents at all. Why that is because people don't want to talk about death. I mean, let's be honest, who wants to talk about dying, right? That's not a pleasant topic. Number two, other significant events in our family life take precedence, which is weddings, baby showers, Diwali celebrations, and you name it. And it's okay. I mean, that's understandable. So it's not an easy topic to discuss, especially when it comes to your family members' well-being. But I think it's imperative, and I'm glad Gamma is at least putting this on for their members, to educate them that it's important to have certain documents at a minimum in your file. We're going to talk about several of those documents in depth today, but interrupt with any questions. I think Sisimon and his group is going to take those questions and interject during my presentation. So let's start with the basic, very basic. If you don't have a will, the state of Texas has a statute called intestate, I-N-S-T-A-T, intestate succession, which means by default, if a husband dies, we always kill the husband for some reason, because I guess the wives outlive the husbands. So historically, actuarial tables tell us. So the husband passes, assuming it's the first marriage, the surviving spouse inherits, in Texas anyway, the husband's 1/2 community property. That's just by law. assuming it's the first marriage. If both children inherit the property, right? So that's the significance of intestate. So don't let anyone tell you just because you don't have a will that you'll lose everything. The state of Texas has a statute, a default statute that allows you to inherit the survivor's property. Now, it gets complicated if you're into a second marriage or third marriage. We're not going to get into that, but then life becomes really complicated. Now, why do you need a will, right? Because a will you can generate from Office Depot or some website, living.com, you name it. There's a lot of websites out there that will generate a will for you. The significance of a will, quite frankly, is to avoid issues upon your death as far as passage of your assets. So what I'm going to do, see if I can share the screen that I have, and hopefully the fact pattern, let me see here. Share screen. There we go. So when I went to law school, I always had my professors put up a fact scenario. So we're going to use the Rumman family. So we have Mike Rumman, who established a profitable IT staffing company 12 years ago, and his wife, Tina, works at a management company at a Fortune 500 company. During 2018, they entered into a partnership to own and operate an Indian restaurant, of all things, with a close relative in Austin area. They also signed a long-term lease guaranteeing the loan to Wells Fargo. Rummans also own a 20% of interest in the hotel in California. More importantly, due to the downturn in the Austin market and California having difficult times meeting debt service, COVID, and more importantly, the relative is under recording sales at the restaurant, right? They have a nice 5-bedroom house with a small mortgage balance. They also have 2 daughters, ages 12 and 14, with some savings set aside for them. I bring this fact scenario is, I'm sure at some point, some of the people on this presentation can relate to some of these things, whether you're an entrepreneur, or whether you have 1 or 2 children, or whether you're part of a partnership in which you have exposure to assets and liabilities or whatnot. So part of today's presentation is going to center around how to also preserve your assets against creditors and also to pass it to your next generation of family members, right? So what's going to be the focus here is to guard against lenders suing against personal guarantees, landlords suing against balance for leases, HR employee claims, sales taxes, and whatnot. That's what you're trying to protect against. Employee claims, liquidity issues, preserve assets for future generations, right? So at a very minimum, you need to have a will in your portfolio of documents. Now, a will, in essence, says what happens to your property upon the first person's death. In Texas, it's important to understand that $1 of your assets between the husband and wife, 50 cents is owned by the wife and 50 cents is owned by the husband just because of community property law. Even though it may be titled just in your own name, unless it's sold in separate property, under Texas law, it's considered as community property. So you can only dispose of your 1/2. So if you have a house, half of your house belongs to your wife and half belongs to the husband. So the will can only dispose of your particular asset, not your spouse's. So you necessarily have one will for each person. The reason to have a will is that if you have minor children under 18 years of age, you can appoint a guardian within that will in case both you and the spouse no longer exist on this earth, right? In the DFW area, sometime back, we've had foreign H-1B workers, we've had green card holders, and even US citizens who are in the country but have no will, and they have minor children. And unfortunately, both parents die in a common car accident, or they're on vacation and they, God forbid, meet with an accident where both of them pass away. Absent a will, which appoints a guardian to take care of those children until they reach age 18, then the court system steps in to say, okay, who are going to take care of this children's day-to-day activities, going to school, taking them to the doctors, who's going to take care of them, right? So a will specifies who the guardian of your children are going to be in the event both of you do not exist in this world. Now, we've done some research and we're able to tell you that in some of our wills, some clients will say, well, I want my brother who resides in India to be the guardian of my children in case the wife and husband are no longer in this world. Texas does allow that. So you're able to appoint your brother, sister, mother, father, etc., who are overseas as guardian of your children. There's just a little formality involved for them to transport the children back to India or overseas in the event that they become guardians of your children. But absent the appointment of a guardian in your will, if you had no will, the courts will then determine who the guardian of the children are going to be. Now, they're not just going to give them to somebody. They'll either go to Child Protective Services and they will appoint a guardian through the court system, or some relative or third-party friend will step in saying, well, hey, we want to take custody of the children, we'll treat them right, et cetera. But in that event, they may have to do a home study to make sure that they're qualified and they don't have a criminal background, et cetera, et cetera. But if you want to avoid all those issues, the will can simply say who the guardian of your children are going to be in the event both of you are not here until the children reach 18. Now, the other concern that's addressed in the wills typically is what happens when both husband and wife are no longer in this world. Does the money go directly to the children? I.e., let's assume both husband and wife pass away and the children are under age 25, just hypothetically. In our scenario, we had children 12 and 14 years of age. Well, they cannot manage the money until they reach 18, right? Because they're minors. So you got to appoint a trustee to manage the money on behalf of the children at that point. Either the guardian can handle the money, or you can create a separate children's trust, is what we call it, within the will. Typically, we advise clients, depending on the amount of assets we're talking about, that the children's trust should continue until the child reaches age 30, at which point the trustee gives all the money to the child, if that's what the intent is. If we're talking a large amount of money for some of our clients, we end up creating the children's trust for an extended time period, such as for during their entire lifespan, so that the money doesn't come out directly to them, but it's maintained in the trust. And the benefit of having a children's trust within the will is that your children, God forbid, marry the wrong person, right? Let's assume they get out of college, they meet somebody and everything's honky-dory and they end up marrying this person at age 25 or 30. You know, we've been in this country long enough, most of us, to know that divorce is a fact of life. If they get divorced and the money is in your child's name, well, that money is exposed to that divorce proceeding because it's considered potentially a community property asset unless your child kept it in a separate bank account aside from the money that they generated during their lifetime. So a children's trust protects against potential divorces of your children. Number two, it protects against the creditors of your children. So in this case, we had the husband and wife had executed a restaurant lease and a mortgage with Wells Fargo for their restaurant. If your children in the future want to start their own businesses, et cetera, and they personally guarantee some of the debt, guess what? That asset in their individual name, as opposed to a trust, which is created by you within the will, is exposed to them for collection against judgments. If they have to, God forbid, declare bankruptcy, the money that's sitting in the trust will be protected from the children's creditors. As we know, we're Asian Americans, obviously, right? Most of our kids, touch wood, are going to be professionals, entrepreneurs, doctors, lawyers, engineers, whatnot, right? They're going to be exposed to their own creditors in their line of work. So why give the money directly to them upon both husband and wife passing? Why not create a trust within the will in which the money is accumulated for their benefit? They can get the money for what we call health, education, maintenance, and support. It's called the HEMS standard, HEMS. And that standard protects them from having to distribute for any reason. So the will is imperative, in my opinion. If you don't have a will, I encourage you to consider having one for at a minimum to protect against not naming a guardian. If you have guardians, then name them in the will and you're good to go. If you have a elderly parent that you support, maybe in the will, you want to name them as a beneficiary of certain dollar amount, whether it's a lump sum, $100,000, $200,000, whatever it is, you need to go ahead and name your elderly parents as beneficiaries within that will. Now, the will technically is universal. It controls all of your assets, whether in America or India or any part of the world. It's universal in that sense. But in order for this will to have any influence with your assets in India, it would have to be probated in America with a judge in the probate court, stamp of approval. Then it gets shipped to India to handle your flat, your other accounts or assets in India. Now, what I've encouraged most of my clients is let's not go through that headache of trying to have this will address your assets in India. I don't think it's beneficial. It's not economical. So what I tell a lot of my clients, and they follow it wisely, is the next time you're in India itself, you can insert your wife or your children's name as ultimate beneficiaries in your absence. That's step one. If you need to name them in your flat or your land or whatnot that you have over there, go ahead and put them there with their name, social security number, identification information, so that upon either one of your death or both of your death, you have their name already ready to go in India. Absent that, you'd have to take the will from here, probate it, take it to India and administer it there. I don't recommend that. I highly recommend you take care of your assets in India itself. It's just much more economical and efficient that way. So let's talk about the next document, which is called the Durable Power of Attorney. Now,
Mahesh, I have a question about. So you mentioned the guardian, the relatives in India can be a guardian of our children.
Yes.
So that is applicable. What happens if say, for example, in my parents, they are Indian citizen, right? And so is it legal? So how we can put my parents as a guardian of my kids, absence of me and my wife? So
yeah, that's a very good question. So we've had this come up over the last, I would say, 10 to 15 years, where there are two practical considerations. One is the research that we did, some time back indicates that we have clients who are also Hispanic, right? So they want to name people across the border or people in Canada to be the guardian of their children. So the courts in Texas have historically allowed that to be the case. They're saying we will allow a foreign person to be the guardian of children, because in the will you're going to say, I appoint X, Y, and Z, who is my father, right, as the guardian of my children. So you're going to identify that person. And we go a step further and say my parent residing in Mumbai, India, or whatever it is. So that way they have an identification feature in the will. We're not going to put the entire address, but we'll identify them to be able to say it's either father, uncle, whatever it is, number one. The practical issue you run into is that will they physically be able to come to America to take custody of the children, absent a B1, B2 visitor visa? How do they come to America, right? Because the entry is limited by the embassy in India. Sure, they show the death certificate. They say, look, our children passed away. We want to go to their funeral, we get it, right? But that's not a guarantee that they're going to physically be able to come to America to take custody. So what we've done in those situations after consulting with the client is we'll appoint an immediate friend here physically as the initial guardian. Then we will name the parents or aunt or uncle as the alternative guardian.
Okay.
So that then that person or friend or close family friend who's in America, let's say your next door neighbor or your community member, well, then as long as they're willing to be the guardian, you tell them, hey, I've named you as the guardian. In our absence, upon our death or whatnot, then we want you to physically, and they would have that capacity to take over. Once they do, they can resign.
Okay.
And your will says the alternative is going to be these people, right?
Yep.
So that's the practical way if there's a question about the entry into America.
Okay, thank you.
Yeah, sure, no worries. Very good question. So the durable power of attorney, is required for your property, right? Because right now, you'd be amazed. A lot of people say, well, you know, husband and wife, our house is owned in our own individual husband and wife's name. Why can't I just sell the property? Well, Texas is a community property state. So half of your house belong to your wife, half belongs to you. You cannot just literally sell your house without your wife's consent. Let's say, God forbid, you're in a car accident or you have a stroke and you're disabled, right? And you cannot sign. You're still alive, but you're disabled for purposes of executing any documents. Under Texas law and most other states, you'd have to go to court and get a guardian appointed for you so your assets can be managed for you. Well, if you have it, and that's expensive, by the way, to get a lawyer, go to court, get a guardian appointed for you to be able to transfer your assets around. If you had a durable power of attorney, which is over your property, your assets, that would prevent having to go to court for a guardianship. And durable power of attorney is a very useful document. It's durable because it's effective even when you're disabled. So typically we have husband gives it to the wife, and obviously this is a very powerful document because it's effective the day that you sign it, or you can make it effective only upon disability. So you have two choices. You know, I've been doing this for 30 years. So when I have a young couple who's been married 5 years or less, I say, hey, buddy, you know, this may not be the most efficient thing for you to give each other a power of attorney. Maybe you want to give it to your brother, sister, mother, father, initially, who's in the US, that capacity. And 5, 10 years later, when the marriage is stabilized and everything is nice, then, you know, appoint each other as the durable power of attorney. But I would highly recommend that you have a durable power of attorney. Now, in addition to that, you should definitely have a medical power of attorney, because if you're in a state of coma, you're incapable of making medical decisions as far as performing surgery, et cetera, then you appoint alternative people to have the power to tell the doctor, yes, perform this surgery, do this, X, Y, and Z, because absent that, unless it's an emergency situation, most medical providers will say, hey, who are you? Or do you have the power to make the medical decisions on behalf of husband or wife or whatever the case may be? Now, the directive to physician is another hot topic for some people, and we typically put that as part of our package. That's whether or not to withdraw life support if you're in a state of coma where the doctor says your chances of survival are very minimal. So the directive to physician will override the medical power of attorney holder's decision relative to whether or not to withdraw life support. So if you have the medical power of attorney and the directive to physician, you're literally telling the physician, go ahead and withdraw life support if I'm beyond, you know, all you're doing is keeping me alive for purposes of survival. You know, you're just putting me on the ventilator and there's probably no chance of survival. The reason I recommend having the directive to physician is that it takes away the burden, if you will, on the medical power of attorney holder to decide whether or not to continue life support or not. Now, you'd be amazed. We've had clients in our office, husband, wife, mother, father, with their son and daughters and whatnot, and they never have this discussion about, hey, what happens if I'm in a vegetative state? What should happen to me? 99% of the time, the person says, remove the life support. The surprising part is the person that they're sitting next to, whether it's their wife or their son or daughter, says, why? Okay, I am not kidding you. We've had people in our conference room literally cry tears when the elderly father or mother or whatnot, or husband says, hey, I do not want to live in a vegetative state because even if I come out of a deep coma, my quality of life may not be what I want. I don't want to be bound to a wheelchair. I don't want to go through hell just to be physically alive. Right now, if you don't have that discussion within your family, how are they supposed to know? How is the medical power of attorney supposed to know what direction you want to go with your life if you ever find yourself in that condition? Because you can't communicate, right? So now the burden falls on the medical power of attorney whether or not to provide that continuous support or not. Then you've got 5 or 10 family members with their own opinion on what should happen to their son, daughter, brother, sister, whatever the case may be, right? So now you created this internal turmoil, so to speak. But had you executed the directive of the physician, or had you said to your spouse or to your close family members, hey, I have decided not to execute the directive of the physician. I want my husband or my wife to make that decision. Great. Everybody knows in the family or close family members at least that, hey, Mahesh says he wants to live till his last breath. But if Mahesh says, look, if I'm ever in a vegetative state and I'm in a coma for X number of days or whatever it is, pull the damn plug. Mahesh is ready to go. At that point, there's no ill will in the family. There's no turmoil within the close family members, husband, wife, children, or whatnot. So this is what I call a Sunday morning over breakfast discussion with your close family members, especially the husband and wife together. If you have adult children, maybe they need to be part of this discussion. If you have parents living with you, maybe they need to be told, hey, here's what we've signed or we're about to sign, just so you know. Because God forbid you ever find yourself in that condition, you don't want to unnecessarily put a lot of burden on each other. And these issues came up during COVID, believe it or not, more often as well. The next document we highly recommend people have is the HIPAA release, which is your personal healthcare information. Most of you may know, or some of you may not know, I'm not sure. A husband or wife have no direct access to each other's medical information. Consider if you have children who are going to college, you pack them up, send them to UT Austin or Texas Tech or Duke or Baylor or wherever they may be going. You, as a parent, have no access to their medical information absent the HIPAA release. So Lord and behold, during COVID, people in our area got all concerned, rightfully so. So they had their college-age kids execute the HIPAA releases so at least they can get information on their children. Because otherwise they're over 18. That physician, if they're doing their job right, says, hey, Mr. Patel, I cannot release your daughter's information to you. Sorry, go get a HIPAA. Same thing with an elderly relative or mother-in-law, father-in-law who's living with you, and the daughter-in-law takes them to the hospital or to the doctor's visit. And the doctor, if they're doing their job, says, Mr. So-and-so or Mrs. So-and-so, please step into the waiting area. We cannot have you in the treatment room or examination room absent a HIPAA release because it's confidential medical information. So if you don't have it, I would highly recommend you get the HIPAA release at a minimum. It's a standard Texas form. A lot of times you'll sign this either before surgery or when you go to the doctor. If you don't have it, we definitely recommend that. The next one we definitely recommend is called a Declaration of Guardian. So the Declaration of Guardian are two forms. We talked about the Declaration of Guardian for the minor children within the will, but understand the will is only effective when you die. It has no meaning while you're still alive and breathing, right? The will is when you pass away, you go to court and you probate it and you appoint the guardian. But let's assume you're going to India for a week or two, or you're going to Cancun for a week, or whatever it is, and your children are with your best friend or your relative or whatnot. Something happens to your child, or you want to have the child picked up from daycare or from some other summer camp or whatnot. You can appoint a guardian for your children now so that they would have the ability to give them medical treatment, take them to school, drop them off. That's over your children under 18. You declare that now, you physically sign it, and you're good to go. You're still alive. There's a guardian for adults. Now, I don't think anyone in this group probably fits this definition, but if you're over 65 and maybe even 70ish, you're starting to get Alzheimer's, dementia, potentially down the road, maybe it's a good time to declare your guardian so that they can take you to the nursing home in the event the need arises. Or if God forbid, along with the Declaration of Guardian, you have the medical power of attorney, they can take you to the nursing home / hospice care, wherever the case may be. But at least you have a plan of action in place in the event the need arises, right? The next document is the organ donation. Now, some of you may already have it based on your driver's license renewal, maybe not. But again, that's something that should be there if that's of concern to you. Now, one other practical thing that's not a legal thing is a lot of people have safety deposit boxes in our community. That has nothing to do with the will in terms of, what goes in there, because no one knows, right? You got jewelry, you got some other information and other items of value in that safety deposit box. Well, it's normally it's just husband and wife who have access to it because they've not appointed anybody else. Something happens to both of them, how do we access that? I have to use the will to go to court to get the order to open the safety deposit box. But if you have elderly brother, sister, whoever, maybe you want to take them to the bank and put them as additional people with access to the safety deposit box. If you have an adult child or two, maybe put them as additional people who have access to it. But you have to take action now in order for that to make sense, right? A lot of this is just practical things that you should consider. Right? Now, we always have clients who say, well, Mahesh, I don't mind doing a will, but I only have one or two assets. Do I really need a will? And I tell them, look, buddy, if you have a minor child, there's no question that you need a will, in my personal opinion. Now, sometimes we'll have elderly clients who only have one or two assets. Maybe they have a bank account and a house, right? That's easy enough. So the alternative to doing the will is if you talk to your bank, they should be able to create what's called a JTWROS, Joint Tenants with Right of Survivorship account. What that means is when husband or wife dies, or when they both die, the survivor end up taking the account over. Similarly, you can do what's called a POD, payable on death, with the bank. And again, this relates mostly to financial accounts. So if you have bank accounts and such, you can name them TOD or POD, payable on death, transfer on death. More recently in Texas, where we have clients only have one or two assets, let's say primarily the house, you can do what's called a transfer on death deeds for the house. We've had that come up recently where some clients only have their primary house and say, hey, upon my death, I want to give it to my two daughters. Great. We do this transfer on death deed, we record it in the county records, and when the husband or wife dies, whoever's surviving gets it. If they both die, the kids get it, everybody's good to go. So I don't necessarily have to worry too terribly much about some of the other items. You can do a custodial account for your minor children until age 21. So again, those are okay, but they're inefficient in my calculation because it only accomplishes part of what you want to do, which is upon husband's death, it goes to wife. Upon wife's death, it goes to the kids potentially. Then what? All right. So if you're concerned about them mismanaging the assets, or if you're worried about their creditors, if you're worried about their potential spouse's claims to the assets that you're leaving them, these alternative features do not get you where you want to go to protect your children and transfer your wealth on a multi-generational transfer process. And it's a quick and easy way to transfer assets, but it doesn't really protect them from their creditors and spouses necessarily, right? So here's how a will works. The will basically says when the husband or wife dies, give it to the wife for lifetime. Then as we discussed just previously, do the children get it directly or should they get it in trust? And this is where you're going to have discussions with your attorney locally or whatnot to say, oh, how do I get it to my kids? Do I just give it to them directly? If the assets are not that much, maybe, but if the assets are significant, maybe you do want to put it in trust for their lifetime or until a certain age and have your brother, sister, aunt, uncle, Wells Fargo for that matter, manage the money for them until they're capable of managing it, right? So the will has to go through what's called a probate process. It has to be filed upon death, okay, not before death. Upon death, it gets filed with the court. The court has a hearing in which they issue a letters testamentary, and upon the hearing, you file an inventory of your assets, you notify your creditors if you have any, then the assets are distributed to the beneficiaries and to pay off the creditors any money that's owed to them. Now, this probate process, luckily for us in Texas, is not too bad. It takes anywhere from 4 to 8 months, given whatever court system you're in locally. But it's expensive because what you end up doing is paying the court fees, which is about $200-300. You end up paying the lawyer's fee, which is anywhere from $1,500 to $2,000, right, depending on the experience and expertise of the lawyer. So you're roughly looking about $2,500 just to go through the probate process locally, and spending 4 to 8 months, kind of in limbo, if you will. Otherwise, if you had this inefficient things and your assets aren't all that great, this short circuits that probate process because it just directly goes to whoever you named. Everybody's happy. But if you're worried about the assets going to your children, then you may not have any option but to go through the probate process. Now, there are alternatives. And you may or may not have heard of this document called a revocable living trust. Okay. Some people call it the living trust. We just call it a joint revocable trust. So the idea there is you're transferring your assets into this trust while you're living, as the word says, living trust, a revocable trust, in which you transfer your bank accounts, you transfer your house, transfer any out-of-state properties. We call in our scenario, we had the client having a 20% ownership in a property in California or whatnot. So if you have out-of-state properties, you want to be able to transfer that into the Texas trust to avoid any probate in California or Florida or any other parts of the country. If you have shares in an LLC, then transfer that into the living trust, transfer your holdings with Fidelity or what other, accounts that you have into the living trust, so that upon death, we don't have to worry about the probate process, because most of your assets while you're living is already in the living trust. It's already funded to avoid any issues with respect to transfer of assets. You'd be amazed how many people have come to our office where either just the husband's name appears on the bank account, or both husband and wife's name appear, but they don't have the magic words joint tenants with right of survivorship. So that husband or wife's one-half community property does not automatically belong to the survivor, because they may have wanted their one-half to go to their parents or to the Hare Krishnas or to a non-charitable foundation, right? I mean, it could be any number of places that they want their 50% to go. It's not necessarily that the wife or the husband is automatically entitled to that 50%, right? So, it's always good to do the pre-planning, but this is an alternative. It's called a revocable trust, right? And Siswan, I'm not sure if you have any questions, but now we're kind of getting into the higher level of the nitty-gritty of estate taxation. So I want to pause here if I can and see if anyone has any questions, because we did cover some of the most fundamental things, I'm open to questions before I go into some of the other stuff.
There's one question about the probate cost. I think you already covered that. So it's around, you mentioned around 2,500.
Right.
Around
typically, with the court filing fees and the legal fees involved and whatnot, it's roughly around there. Yeah, at least in the DFW market, because it does, it's a little bit of a process to get there. Yeah, but again.
So Mahesh, I heard that the probate process is just like something percentage of your property you are going to be transferring. Is that something correct, or in some other states?
Very good, James, I believe, right? So
yeah,
and I intentionally didn't mention it. If you happen to be living in California or Florida, God help you, because because a percentage of your probate goes towards legal fees. Because yes, and that's why this revocable trust is a very good mechanism to avoid the expenses of probate. Because let's assume your assets are worth 2 million or $1 million or whatever it is, you end up paying the executor, assuming it's a family member, it's not an issue, but the attorney there in that jurisdiction is going to charge you a percentage of the assets as their fees, because they're entitled to collect that, right?
Yep.
And that's the biggest issue that people have is, hey, why am I paying 2%, 3%, whatever that percentage is it's just free money, right?
Yeah.
Yeah. So if you want to avoid that, then that's one reason, right? Obviously, is to create the revocable living trust. The other reason, quite frankly, and some of you in this conversation may have it, some of you may not, is we've had clients where the mother and father are retired in the DFW area. One daughter is in Boston and the other son is in California, doing their life's work, whether they're engineers or lawyers or doctors or whatnot. And they're like, hey, we don't want to take time out of our busy life upon either mom's or death to come do this probate of their assets. It's just not worth it, right? So if mom and dad had created this revocable trust while they're living, put most of their assets into it, it consolidates all of your assets into one place. So that when son or daughter has to fly in from Boston or New York or California, they're not left to figure out, hey, what did mom and dad own? All they have to do is either talk to the lawyer that helped them or look at their documents in their safety deposit box, assuming they have access to it, right? Which is one of the practical things we talked about is go ahead and add your adult children to the, first of all, disclose to them what you have and where it is, and your user word and your passwords to your bank accounts, right? Then this living trust is your holding mechanism for all or most of your assets. So, yeah, you raise a very good question in that regard. As far as
So Mahesh, then follow up, so who is the trustee for the living trust? Do we have
it's
to
husband
distinguish?
and wife. 99% of the time, it's husband and wife joint trustees, and they're the joint beneficiaries of this living trust. So while husband is alive and wife is alive, they can take money out, pay their household expenses, etc. And they're the owner and they're the beneficiaries.
So what happens after that if both husband and wife dies?
Right. Then we typically, when we do the will and when we do the will plus the revocable trust, we will ask the client, hey, who do you want to succeed you as the trustee of your trust? Because understand, mother and father can still be alive and be disabled either in the form of dementia or Alzheimer's or just mentally not there, right? So you need somebody to manage those assets while the mother and father are still alive and unable to manage their assets. So we always name an alternative trustee in the document. That could be their closest relative, or it could be their adult son or daughter, or a combination of the two, or it could be a corporate trustee. It could be the Wells Fargo or whatnot if they're willing to serve as the trustee. But you need somebody to manage that money either in during their disability, if you will, or upon their death. And typically the children will step into that position.
Okay, good. Thank you.
Yeah. And just to add on to that, James, what happens is sometimes people say, oh, my children are only 18 or 15 now. So what we do is in our document, we'll say, upon reaching the age of 25, our child or our son or daughter can be the trustee of our trust in the event of our disability, right? So we precondition the ability to be the trustee at a certain age.
Okay. Very good.
Yep.
Mahesh, I have one question. Is there any restrictions on attaching a property to a trust if there is a mortgage or lien on it?
No. So let's go back to that. Into the revocable trust, right? This living trust, the joint revocable trust is what we call it. By Texas law, you can transfer your primary homestead into that revocable trust without it triggering the acceleration due on sale or transfer clause, because the state of Texas has recognized that the husband and wife, that they're the joint owner of it or trustee of the trust, and they're also the joint beneficiary of the trust, right? So if it's your primary homestead, you are able to, even with the mortgage on the house, transfer that house into the living trust without any restrictions. And more importantly, when we do our document, when we record the warranty deed transferring from husband and wife to the revocable trust, our warranty deed says for homestead tax purposes, the house is going to be rented to the husband and wife at zero rent. Now, a lot of these counties will say, oh, okay, there's a change of ownership. Please send us a copy of your living trust. We're fine. Here you go. And in the living trust, we explicitly provide that if it's the primary homestead, there is no rent due to anyone. And that's the language that the the county officials are looking for tax purposes, number one. The lenders cannot accelerate the note. Now, if this was a rental property that you're trying to transfer into the revocable trust, good luck, because then the bank will be able to say, hey, this is an illegal transfer under the deed of trust and therefore in violation of our loan documents.
Got it. Thank you.
Yes, sir. So, yep, and keep the questions coming. At least it makes it engaging for everyone if there's any misconceptions. Now,
And Mahesh, I mean, about
Sure.
the living trust, the law says it's same for both immigrants and citizens, right? So someone with a visa, is it same for citizens also?
yeah,
I mean,
yeah, it
okay.
is. Yeah, we've had a number of clients, especially in the recent time period. We have a lot of Chinese nationals coming to the DFW area for whatever reason. They're buying up houses in Frisco, and to educate their kids, they're coming in on the EB-5 visas and other. So we, to avoid any issues, we just go ahead and create the trust for them and do the wills, because what controls is your domicile, right? Where is your place of domicile, your place of residence, right? Even if you're a non-immigrant, you're still residing in the US, unless you're a visitor visa or something like that. But if you're on an H-1B, if you're in EB-5, EB-2, whatever the category is, L-1, you're still residing in America. So yeah, all of this is definitely available to them. Now, the question is, will you get a house loan if you're a non-immigrant? Yeah, maybe, but you'll end up paying a higher rate, maybe a higher down payment,
Yeah.
But there's no restrictions on creating this trust.
Okay, yeah, thank you.
Sure, no worries. So at a high level, right, which is what if some of you are in this category, great. If you're not, maybe, 5-10 years, you may be, right? So purposes of estate taxes, understand there are 3 forms of taxation, right? Income tax, which you all know about. You pay an income tax on your income, whether it's gambling income, it doesn't matter, it's income, right? You pay it. Post-income tax, if you die and you have assets more than $12.06 million, then you're subject to an estate tax, which is a death tax at a rate of 35 to 55%. Okay, so between husband and wife, if you have up to $24 million today, you're fine. There's no issues. Everything's going to be okay. In addition, you can give 16,000. Again, all of this is post-income tax. Okay, to any person in this entire world. You can give it to Sisimon, you can give it to me, you can give it to your son, daughter. 16,000 per person annual gift without using any of your $12 million. That's if you're so inclined, right? Most people don't do that because obviously they want to hang on to their money as long as they can and use it because they don't know if they're going to need the money. But if your assets exceed $12 million, then maybe it's time to consider setting up a different form of trust planning, which, I can present that to you. Some of you may say, what the heck is all this? But typically what would happen is you'd have the living trust, which husband and wife would be the joint beneficiaries and trustees. Upon one party's death, either husband or wife, we would take $12 million and put it into what we call a bypass trust. We would give the wife his or her the remaining portion of the community property. And upon both of their death, all the money would flow down to the children either directly or it continues in trust, right? So that's a higher level of trust planning that you can incorporate if and when the time arises, right? Now, the key thing to keep in mind is we haven't talked about the elephant in the room, which is 401ks and life insurance policies, right? Most of us have 401ks and life insurance policies, I'm willing to bet. So let's tackle the easy one first, life insurance policies, right? So most people name husband or wife as the beneficiary without thinking too much about why, right? So I have young couples all the time come into our office and they, oh, Mahesh Bhai, we just bought, actually they call me Mahesh Uncle in most cases now. So, we just bought a term life of $1 million, $2 million, et cetera, et cetera. And I said, hey, that's very good. Who did you name as the beneficiary? Oh, we named each other, of course, I said, well, okay, so do you support any of your parents? Yeah, they live with us. I'm like, well, do they have any assets to live if both of you or one of you dies? Okay, then they start backpedaling, right? So one of the things, again, it may apply to some of you, it may not. I'm just putting it out there for consideration, is maybe you want to name your parents as a beneficiary for a part of your life insurance. Okay, a fractional, maybe all of it, I don't know. But directly naming husband or wife each other as the outright beneficiary of a life insurance policy is perfect, assuming that's what you want and you're at a later stage in life where you're not worried about some other beneficiary, i.e. your parents, okay? Consider, people are young, they may remarry. So if you name the other spouse as the outright owner 100%, and the wife dies and the husband remarries, well, you know what's going to happen, right? Your children from that particular marriage may not see that money necessarily. Potentially they will, they may not. So why not put it in what we call the ILIT, Irrevocable Life Insurance Trust, as the beneficiary of that life insurance policy, so that the money will be used for the surviving spouse, but then also for your kids from that particular marriage, so that if there is a remarriage, it doesn't get mixed up, if you will, for the lack of a better word, with the second marriage and the second set of kids. Just food for thought, right? More importantly, let's assume none of those issues are there. Husband and wife name each other as a beneficiary, then they always name the kids as the secondary beneficiary. And that in and of itself is problematic. Because if the children are minor, right, if they're under age 18, the life insurance company will not distribute money directly to the children because they're minors, right? Husband and wife die in a common car accident, that they've named the minors who are 12 and 14 as the beneficiaries, secondary beneficiaries. Guess what? That money is going to go to the guardian to conserve the money until the children reach 18, okay? Your brother or your mother or father is a guardian, great, they'll take care of the money till the kids reach 18, okay? What have you done there? You created more of a mess for yourself, because once the kid reaches 18, they're sitting on $1 million cash or whatever that money is. Now, college may or may not be something that's required for them. Or like a Lamborghini or a Porsche or some vacation rental somewhere, God knows, right? So if you leave it directly to your kids, that's really not a bright idea, especially when it relates to life insurance policy. So to the extent you have it, I would caution you to make a list of your life insurance policy, see what the death benefits are and who the secondary or maybe even the primary beneficiaries are. Maybe you want to make a part of it the charity locally that you always give, 10% to. Who knows? I don't know, but just don't take it for granted that your life insurance policy is properly, documented relative to your beneficiaries. It's always advisable to have another look, especially as circumstances change. Your children become older, maybe they marry, maybe you want to take them off as a beneficiary, maybe you want to put in somebody else as who knows, maybe you want to make your joint revocable trust the beneficiary, right? So that all the money comes up at the top level. It goes back up to this right here. The living trust becomes the beneficiary of that life insurance policy, and upon death, it gets divvied up between the bypass trust and whatnot. It goes to your kids. So that's part and parcel of your planning, right? The second asset that a lot of people have is 401ks or Roth IRAs, right? Mr. Trump, before he left office, passed the legislation which makes it very difficult to do a rollover for non-spouses, right? Because right now, trillions of dollars, okay, are parked in 401ks. And the government is bleeding money. There's no way for them to force acceleration of the income tax, at least in the old law, for the sons and daughters of the primary 401ks. They would just normally roll it over to the son and daughter's 401k, and they live another 60, 70 years. And guess what? The government doesn't see the light of day as far as income taxes, unless there's, the required minimum distribution, then the spouse rolls it over, and they preserve the spousal rollover for for the surviving spouse, because they knew politically, if they took that away, they'd have a high price to pay. But what they did do is they said, absent a disabled child, the third-party beneficiary of a 401k, a non-spouse, will have to take the money out within 10 years of getting that money. If they don't, they're going to get hit with a penalty, and they're going to force a distribution at year 10, right? So 401ks, my word to you would be always leave the spouse as the primary beneficiary on 401ks, no issues. But the secondary beneficiary, we already know that the kids are going to have to take the money out within 10 years of them becoming the beneficiary. So why not make the secondary beneficiary the joint revocable trust? So that, God forbid, both of you die close in time or whatnot, or upon the same incident, that the money won't just directly be lumped, distributed out to the kids. At least it'll go to the revocable trust. It'll be protected relative to distribution down the road. Even if they have to take it out within that 10-year span, it's not just going to be diluted to the exposure of your children's creditors or their spouses, right? In the old days, we just made the kids, if they're adult children, the beneficiaries of the 401k, and they rolled it over into their 401k, and life would be fine. But this law that was passed before Trump left office kind of negates the planning for the second level of 401ks. So that's just to keep that in mind forward. I know some of you are green card holders. So going back to the estate taxes, there are limitations on how much you can leave in the US, right? So you've got, for spouses, you're limited. Let's assume you're a US citizen, you have a non-US citizen spouse, a green card holder. We're not going to get too detailed into this, but you need to have what's called the QDOT, Qualified Domestic Trust, for your green card holder spouse. And the reason is the US government is concerned that, let's say Mahesh leaves $12 million to his green card holder spouse. The green card holder spouse relocates to India because the person is not a US citizen. So guess what? She's going to run off to India or Africa or wherever, Germany or whatnot. The US government will never see that money again for tax purposes. So they're saying, we will give you the unlimited marital deduction for your non-green card, non-US citizen spouse, but it has to be a QDOT, which one of the requirements is one of the trustees has to be a US citizen, et cetera, just for your knowledge. So for non-US citizens, the planning is slightly more complicated, and there are limitations on that, okay? We can talk more about it offline if you need to. So let's talk, because I think believe it or not, we've already spent an hour almost to this. So Sisimon, I'm willing to keep going, but if I ever need to stop, we just give you the red light and we'll go from there, right?
Yeah, sure. Yeah, go ahead. Yeah.
Okay. So, and I'm not sure how many of you on this call are business owners per se, but to the extent you are, and we've had this happen all too often where the relative says, hey, I've got this bright idea. I want to start a convenience store. I want to start an Indian restaurant. That's their favorite gig, in this shopping center. Will you guarantee the lease and the loan from Wells Fargo? And say, well, you get the social pressure, from the in-laws or who knows who else, right? Say, well, they're just starting off in America. You really need to help them, et cetera, et cetera. And you're being a good-hearted person. Say, okay, fine, I'll sign the lease, I'll sign the loan with the bank. And as in my scenario at the very beginning, that relative of yours gets really greedy and starts under-reporting to you, starts defaulting on loans and rentals to the landlord. What do? Right? Well, if you're smart, or if you're at least conscious about your liabilities, you need to see if it was a recourse loan or a non-recourse. And most of the time it's the second, which is the unlimited personal guarantees. So sometimes I'll tell clients if you can negotiate with the lender, it's difficult, don't get me wrong, but you tell them, look, I'll limit my liability to 50% because that's what I own in the company. Sometimes they'll go for it, sometimes they won't, right? Maybe you just have one party guaranteed, your spouse, just one of you, not both of you. Then you can potentially protect yourself from that, right? We definitely don't want to go through the bankruptcy, but that's always the last option, Chapter 11. Bankruptcy, which rolls into Chapter 7, not a good idea. So, you know, when you sign the lease, maybe you want to cap your liability to 6 months of rent or whatnot instead of the entire term of the rent. You know, there's a whole lot of things we can talk about relative to leases and whatnot, but they may not be pertinent to this presentation. But if you have it, you know, before you sign on the dotted line, either as on the loan documents or the lease agreements, etc., take account of what you're signing up for. It may cost you, you know, $500, $1,000 to get a local attorney to look through your options and make sure it's all kosher, if you will. Just don't take your relative's word. Oh yeah, it's going to be a great business. We're going to make a ton of money in this nightclub or restaurant. I mean, like I said, I've been doing this for 30 years, and everybody goes in with the best of intentions. And particularly if you're working in your IT firm or your day-to-day job, you don't have time to go mess with your relative to see how they're handling the business, whether they're reporting it to you properly, whether they're treating the employees properly. You know, you'd be amazed how many sexual harassment or discrimination cases are filed by employees against the restaurant owners slash business owners, you know? So you want to be cognizant of those potential liabilities, right? One thing we always advise clients, especially my hotel owner clients, is if you have liquid money sitting around, form a separate holding limited liability company, just a separate LLC. Park your cash, your mutual funds, your what do you call it? Your brokerage accounts into a separate limited liability company. A lot of times we tell our hotel owners to form a management company, but in your case, you could form a limited liability company, just XYZ LLC, and that could be your holding company for your rental houses. It could be a holding company for your liquid assets. You have 200,000, 300,000, 500,000 sitting around in cash. It doesn't do you much good to leave it in your individual name because that's exposed to any creditors, because all they have to do is tap into your SS number, voila, off they go, right? If you have adult children who are driving and they're still in your household, the car is owned by you. Maybe you want to increase your liability coverage for your rent for your car. Maybe you just want to give the car to the kids and take it off your name, assuming they can afford the insurance, right? Or whatever it is, increase your insurance limits on your car. It doesn't cost a whole heck of a lot, believe it or not. I've gone through with my two daughters. One is now 26 and the other one is 24. When they were teenagers and driving, I upped my insurance policy on the car, or an umbrella policy through my house, so that I've got excess insurance policy if something happens. If you're involved in HOAs or if you're involved in your own company, maybe you get the EPLI, Employment Practices Liability Insurance. You know, get as much protection built in as you can outside of the other things. Now, I'm not sure if they're business owners on this call or not, and if you're founders of your own company or along with your partner, your founder, something happens to one of you, what happens? You know, does your shares get bought out by your partner? And if so, is it at a market value? Do you have a buy-sell agreement with your founders, with your business owner? What do you have? Yeah. You want to avoid family dissension. You want to avoid issues with management of a business when you pass away. You know, do you necessarily want family members to be in business together upon your death? Maybe not. You know, if you have adult children, one wants to be in the business and the other one doesn't. Maybe you want to address that during your while you're alive and capable of making those decisions. So, you know, again, we can go through a lot more, but I think, Sisimon, we're at a pretty good stage, unless, you know, that I can bore you guys with more details, but I think we've covered the majority of what we needed to, I think, unless you want to continue, it's up to you.
Yeah, I think we can see if anybody has any questions. So,
Yep.
What is typically the cost for setting up a living trust?
It depends on what's involved, right? I mean, in our office, we charge typically around $2,000 to set up the living trust. And we don't just do the living trust by itself. We combine the living trust with the will, because understand you still need a will, because the will is what we call, in you can Google this, it's called the pour, POUROVER, pour over will. So you have the majority of your terms and conditions in the joint trust. In case you forgot to transfer stuff into the trust while you're living, you still need the will as a backup, right? So we have the revocable trust, we have the will that pours everything over into the trust upon death. Then we always combine it with this package of documents that we discussed earlier, which is the durable power, medical power, HIPAA, all those things, because I think you need to do it as a total package. And typically in our office, we customize it for about $2,000.
Got it. Thank you.
All right, so I'm going to continue this one, if it's okay with you, with the asset protection portion of this.
Yeah, I think we put it. Yeah, I think probably we can wrap it up maybe in another 5 minutes or something.
Yeah, perfect. Yeah, no worries. I mean, if there are questions, I'm always willing to
Yeah.
entertain those. But
Yeah.
So again, one of the things that we kind of briefly touched on in this presentation is how do you protect your assets, right? The biggest way you can do it is not have a title in your own name. If you can avoid it, great. So having it named in your LLC is always one of the best ways to do it. You have to recharacterize how those assets are held, okay? That makes a big difference. Now, under Texas law, limited liability companies, corporations, family limited partnerships, all those are protected. And all those are good asset protection vehicles. Insurance policies are protected. You have retirement plans, annuities, those are fully protected from creditors, right? Irrevocable trusts are protected from creditors, not the revocable, but the irrevocable trust. Now you may say, why do I need an irrevocable trust? Maybe if you want to start gifting things to your children now, right? You could create a separate trust for your children so that you can put $16,000 per year with the husband and wife, $32,000 per child into a separate trust for the child. You can do a 529 for your child for college purposes, or you can do a custodial account. Those are okay, but if you want a long-term solution, you may consider an irrevocable trust for your children to park some excess money so that it's protected. Your homestead, your house, which we briefly touched earlier, if it's your primary house, that's protected from from creditors. So, it's always important to keep that in mind. Homestead, if you have a house, ideally pay it off if you can, so that you don't have to worry about any issues, right? Your IRAs, 401ks are protected. You're under Texas, it may not necessarily apply to all of you on this call, but sometimes we have physicians that are worried about liability. So we'll separate their assets. Let's assume they have 10 million in assets. Husband will say, hey, honey, here's your $5 or $6 million. That's your property. You can do whatever you want with it. So that if the doctor gets sued in his practice, that money that's in his wife's sole and separate account is protected from that lawsuit, right? So there are ways that you can protect some of your hard-earned money. Homestead, obviously, we touched on. So the limited partnerships or LLCs, those are highly recommended for people who are worried about protecting assets, especially if you have rental houses. Assuming there's no loan on the rental house, then maybe you should form a separate limited partnership or an LLC and transfer that house in there. And the reason most banks don't want you to transfer that into there without their permission is because they're underwritten as a multifamily house loan, not a commercial loan. So they're a little concerned about that. So with that, I appreciate everyone's attendance today and to the Board of Directors at Gamma, thank you very much for the invitation, and Sisimon, thank you for arranging it. And
Yeah.
yeah.
Thank you. Thank you, Mahesh. Yeah, this is really useful. And I was thinking about the will and trust for last 7-8 years because my employer is giving a free of cost to all employees, and I never did that so far because I was not aware of the importance, and I put it on low priority so far. This is same for many of my friends and colleagues, and thank you for educating all of us together. Appreciate that. And thank you, community members, for joining, and those who raised questions. Yeah, thank for everyone. I think we can wrap it up. Thank you.
Yes, sir. Hey, thank you, guys. Take care.
Yeah.
Thank you.
All right. Bye-bye.
Bye.